Hi, I'm Brian Resnick.
And I'm Hal Resnick.
Welcome back to the conference room for episode 3 of Real Estate with the Resnicks, The Power of the Deed.
Once you find a property to buy, deciding how you want to hold title is almost as important.
Most people spend weeks picking out kitchen tiles, but only 30 seconds deciding how they want to hold title.
How you own your home is just as important as what you own. It dictates taxes, inheritance, legal liabilities, many issues and concerns that come along with that.
Yeah, and I don't know about you, Hal, but when I ask the question, how do you want to hold title, I get a lot of blank stares.
Because people have no idea what that even means most of the time.
Yeah. I think some people still think when we talk about title, they think we're talking about their cars and tags and licenses, not necessarily real estate.
No, and I try and steer them away from the ones that cause the most problems, ones that are hopefully in their best interest. Sometimes some even need an attorney to get involved to help get answers.
For sure. There are a few typical ways to take title to real property, and also a couple more complex ways. Let's dive in and discuss some of them.
All right, the first one we want to talk about is tenants in common. By definition, this is an ownership of two or more people where the interests aren't necessarily equal, meaning that each one can own a specific percentage of ownership in a property. And I will throw in at this point that this is the one that tends to cause the most title problems, because if you have a judgment that gets put against you, that judgment or issue has to get resolved before you would be able to sell title. So there's no real protection here from tenants in common. So this is one of the ones that we definitely have conversations about with people when they're interested in this tenancy.
Yeah, I mean definitely. This isn't one you would typically see for couples or married couples or family members. This is typically something we'll see maybe in a second marriage where one party wants to protect their assets and make sure that their percentage of ownership goes to their heirs and not necessarily their spouse's heirs.
Also we'd see it sometimes if friends, let's say, want to buy a house and they're going to rehab it and try and sell. They might own it as tenants in common. They each want to know the money they're putting up is protected by their ownership percentage. So sometimes we'd see it in tenants in common in that scenario as well.
Yeah, and the other thing to remember, and Hal, you may have just said this, but in this particular case, if there's multiple owners, there are multiple owners because it's tenants in common. If one party passes away, the property does not go to the other party. It goes however you have your will, your estate, whatever it is designated. That's who your portion of the property goes to. It doesn't automatically go to the other owners of the property.
Correct. Your estate would have to transfer that portion with your personal representative now in charge of that, where that goes. It's not given to anybody automatically. It has to be transferred to somebody through personal representative appointment and then them deeding out that interest to somebody else. It could be the same people, but it's not automatic. It has to be done through a deed being recorded.
Through probate. With that in mind, the second tenancy that we want to discuss is called joint tenants. By definition, joint tenants is equal ownership with the right of survivorship by two or more people. All parties together own 100% of the property. Each individual doesn't own a certain percentage or 100%. Everybody together owns 100% of the property. Upon the death of one party, the transfer to the other parties would then be automatic by virtue of the deed without having to go through probate. If one party does sell the share of their property without the approval or the knowledge of the other parties, then that property would then become tenants in common automatically, and it would strip out the right of survivorship. We will often see joint tenants used by unmarried couples. Maybe it's a couple that is engaged, they're going to get married, family members who want to have a seamless ownership, a transfer of ownership. That's usually who we'll see who use joint tenants. And then to create a joint tenant, there are 4 elements that have to be met. Hal, why don't you talk about the 4 unities?
So the 4 unities break down like this: possession, interest, time, and title. And they must exist simultaneously. So in essence, you have to take title together at the same time with the same deed, and everybody has the same percentage of ownership interest. So again, with the definition of joint tenants being everybody's entitled together and they own the same amount of house, that's why this has to follow suit with that tenancy. So these 4 things have to be met in order to support the joint tenants, because again, without these 4 requirements being met, you fall right back into tenants in common, where tenancy would be broken in essence, and you wind up with a lesser tenancy where you don't have survivorship, where you don't have protection from liens or judgments or issues or problems. And joint tenancy is a much better way to protect yourself if you can get that tenancy with the people you're buying a house with.
And an example of acquiring title all at the same time, other than obviously just everybody buys a house together, is let's say a parent wants to add a child onto their deed with them for estate planning purposes or whatever. The deed doesn't say mom and dad want to add daughter to title. It actually says the property is being transferred from mom and dad to mom, dad, and daughter. So everybody is at that point acquiring title at the same exact time. So it's not done at separate times. It all meets the elements of the 4 unities. So that is able to become joint tenants.
Correct. That meets the requirements. I mean, we do plenty of legal deeds like that. We do that for people all the time when we're helping them transfer title interest. We'll get an attorney involved. They'll draft the document. We'll present it. We'll get it notarized, and then we'll go do the recordation portion of that to satisfy what their requests are.
Yeah, and sometimes it's just people who want to do that just for estate planning purposes. Sometimes it's somebody that's going through a refinance and the lender is requiring, if they want to add another borrower, they're requiring that other borrower needs to be added to title or removed from title if it's a divorce situation. So there's lots of times where as a title company, we have to step in and assist in preparing a deed outside of a standard purchase.
Right. Agreed.
And then similar to joint tenants, we also have a special form of ownership that's reserved for married couples. We call that tenants by the entirety, or T by E is oftentimes referred to.
Quick reminder, when we discuss topics we're talking about what is to be true in Maryland. This particular tenancy is recognized in about 25 states throughout the country, but it's not universally accepted. Different states have different terminology for deeds, different coverages for deeds, different kinds of deeds, quite frankly. But in Maryland, tenants by the entirety is the most favorable deed for a married couple, as we would discuss, because it protects their ownership interest as them as a 100% entity, protects the house from judgments, issues, problems. It really is the gold standard of coverage.
And that's exactly what I was going to say. T by E is considered or can be considered the gold standard because of the coverages that it does provide. There is unmatched creditor protection. As Hal just mentioned, if a creditor wants to attach a lien to an individual, it can't go against the house that is titled as a tenants by the entirety, because the house is a marital asset and that creditor would be going after one individual, so it can't attach. But if there's a joint debt, like a mortgage or a joint tax debt, a lien could then be placed on the property because that is on both parties. Like joint tenants, it does have the automatic transfer of the property if upon one death to the surviving spouse, and it would do that without having to go through probate. Tenants by the entirety also offers unified control, meaning that no one spouse can act unilaterally to sell, give away, or mortgage the property. This prevents one spouse from making reckless financial decisions that negatively affects the other. So in essence, any decision that's made for that property, if they want to sell it, they want to place a loan against it, a mortgage, both parties have to be a part of that transaction. They can't do it on their own.
No one's selling the house and going to the casino without the other one knowing.
I mean, just don't tell my wife.
And that's fine. I just wanted to mention also, federal tax liens and state tax liens will supersede this tenancy. So there are still some restrictions, if you will, for tenants by the entirety. And I know Brian mentioned the tax liens real quickly. So if you have a federal or something from the state of Maryland that is a tax lien related, that would be something that would still have to be addressed before this couple who owns tenants by the entirety would be able to sell the property.
Yeah, good point.
All right, so moving on now to life and trust ownership. As we've discussed the most common tenancies, there's others used for different purposes. So we see life estate deeds from time to time, and it's a good tool for certain people. And again, this is another deed that's called different things in different states. I've learned there's something called a time of death deed, which in essence is very similar to what a life estate deed. And a life estate deed is a legal tool that divides property ownership between the current occupant or the life tenant and a future beneficiary, the remainderment. It's a lot of times used for estate planning purposes where parents will leave to a child. At death, the property automatically becomes owned by the child, the survivor of them. And it doesn't go through probate, it doesn't go through estate planning. The deed itself is the estate plan, and that moves the house right to them. This tenancy allows the life tenant, to live in their property for the rest of their natural life, and then again, automatically transfers to the remainder that they have assigned, again, without going through probate. Potential tax advantages, it's always worth talking to accountants and asking questions, but upon death, the property typically receives a step up in their tax basis to current market value, which can minimize capital gains for heirs if they choose to sell. It could be a good idea for Medicaid planning. By establishing a life estate, it can protect your home from Medicaid estate recovery, provided the deed is executed outside the standard 5-year look-back period, and it also avoids probate, no costly time-consuming court processes.
I mean, if you're thinking about utilizing a life estate deed, we would certainly recommend that you talk to an estates and trust attorney and just be sure to discuss the powers that are or are not inherent in that document. In a standard life estate, the tenant loses unilateral control over the property. That means that if you want to refinance, sell, or mortgage the home, you would actually have to have the remaindermen join in the transaction with you. And if they have any objections, that could cause problems. If you have to sell the home for financial or other reasons, you're reliant on that remainderman to agree with the sale, and they could potentially want to divide the proceeds with you. This could lead to all kinds of problems, including family conflict. There's also an exposure to credit risk here. If the remainderman faces financial difficulties such as a bankruptcy or a divorce, their future interest in the property could be targeted by their creditors.
So from what I've seen, as I mentioned before, with tenants in common being the most common tenancy that causes issues with title, life estate with no powers, number 2. Most of the deeds that we see and prepare is going to be a life estate with full powers, meaning that the life tenant can do everything they want or anything they want with that house without asking permission from the remainder people. It gives you the freedom to continue to live there. You could refinance. You could take out a home equity line of credit, what have you. Whatever you want to do to that property, it's your ability to do that without asking anybody for permission.
Including selling it?
Yeah, that's right, including selling it. Upon your death, the house still passes to your remainder person. Exactly the same with no powers. But with full powers, it just gives you the authority and right to do whatever you want with this house without asking anybody for permission.
Yeah, absolutely. And then there's other alternatives to life estate deeds. For example, we have revocable or irrevocable trusts. Not easy to say. A revocable trust functions as a flexible substitute for a will, which allows you to retain complete authority over the property during your lifetime. There are a few steps in order to accomplish this. The first step is you have to establish the trust. You have to work with an estate's attorney to set it all up, and then once that trust is established, you would then need to transfer the home into the trust and under the control of the trustee, which with a revocable trust is typically yourself. It's typically the homeowner. You get to retain 100% of control of the property, which allows you to sell it, refinance it. You can change the beneficiaries. And then if you want to, you could even dissolve the trust anytime without anybody else's permission. By doing this, upon your death, the property will again transfer without probate directly to the beneficiaries named in the trust. Since you retain full control of the property, you are not afforded any protections against lawsuits. Creditors, Medicaid estate recovery, things of that nature, they can attach to the house because you are the beneficiary of that trust.
Right. And then if you want to do the same idea with some protections, you could have an irrevocable trust set up, which is often used for... What'd you say?
I said, not so hard for you to say.
I say it more often, I guess. So the irrevocable trust is often used for long-term asset protection and tax planning. And it works in almost the same way, but you must name an independent trustee, which is as an adult child or a professional trustee to manage the asset in the trust. You lose unilateral control. As soon as you place the asset in trust, you're not generally able to change the terms, hence the name irrevocable. You can't remove assets, you can't revoke the trust without the written consent of the beneficiaries, who would also be set up as the trust is set up. That's where those would be appointed and determined. Again, this option avoids probate, but also offers some strong asset protection. Since the home is owned by the trust and not by you, it shields the property from personal lawsuits, judgments, liabilities, certain debts, and provided set up outside the 5-year look-back period, it also protects Medicaid estate recovery.
Yeah, and no matter what your situation is, don't make a tenancy decision just on a whim. Discuss it with your advisors, whether that's your realtor, your loan officer, your title company, and obviously your attorney. While tenancies can, under most circumstances, be updated throughout your life, you can avoid some short-term issues by making the right decision from the start.
And I would add, in addition to the list of people you want to go through, talk to an accountant too. You want to make sure that what you're doing here is not going to have tax implications in any way, shape, or form, or at least you have an understanding of how that all works. And as we know, life's change over time. Married, divorced, kids, remarried. As things change and occur, you can review your deed and update it as you see fit. reach out to an attorney, to your title company, guidance and assistant. This is something that we do often. At some point, you may get to meet our father, Stuart. Stuart does a lot of our legal deeds. I get lots of requests from past clients who want to change tenancy, title, names change for any particular reason, and we'll engage him to help with the deed preparation, and then we'll process and record through our office. So
yeah, outside a transaction that we're involved in, there's a couple more steps that we have to take to prepare those documents. So that's oftentimes why we would then reach out to our father or to one of the attorneys that we have within the company.
Correct.
Now, some of the things that we look for, some of the red flags that we look for, like when we get a purchase or a refinance order, we're going to compare that contract. We're going to compare the title order with the deed that's on record. We're going to pull that current deed, and we're going to see how the names are currently held in title, and we're going to look at the contract to make sure that they match up. We're looking to make sure that the names match, that the parties have the authority to do what they're trying to do. For example, sometimes we might receive a refinance request from a lender. It shows that Mr. and Mrs. Smith is the borrowers. But when we pull the current deed, we want to make sure that Mr. and Mr. Smith is currently entitled. If we see Mr. Smith is alone in title or Mrs. Smith is alone in title, that's gonna make us ask questions. We want to know what's going on. Did they know that it was done that way? Then we're going to go ask the lender, hey, you have two borrowers, but only one person in title. Do we need to update the deed so that this matches? And we're going to work backwards with the lender and with the homeowners to get guidance on how we need to move forward. Some of the questions that may come up. When the house was originally purchased, it was purchased by one of the parties, and then they got married down the line and never updated the deed. But now they're trying to do a refinance together, and that's when we find these differences. And then depending on the responses, as I mentioned, we'll work with everybody, the lender, the borrowers. If we need to prepare a new deed, we'll do that. We'll work with the borrowers, the homeowners, to get the deed signed and then recorded. So make sure that everything aligns.
Yeah, and that's just some examples of different scenarios. We'll see one person in title now, a contract will come in with one name, and Brian referenced some, but somebody could have passed away. Someone was a former spouse or ex-boyfriend or girlfriend. A crazy example, we had one that showed up and someone was in title that the person had been in contact in years. We were able somehow to track them down through Facebook and got them to sign off on title.
The power of social media.
It's unbelievable. We had one where there was a judgment involved, same thing. We found a name, we did some research, and we found someone, and we were able to get them to release a judgment. So there's all kinds of things that we'll go through, tenancy, social media, just to try and clean some of this stuff up, because the parties have to match the title. Most lenders are going to want refinance to match who's in title. Buyers may want, or owners may want, to have certain names in title in order to do refinancing, and that's where we'll get the deeds. We'll work on the tenancy. We'll make sure that we're the able to advise and help out and get people put in the right direction and successfully add whoever they need to or remove however they need to and close whatever else they have going on with it.
Yeah, so for today, we're going to give you a little bit of homework. The takeaway action item for today is go look at your deed, see what it says. Did you and your husband, you and your wife, did you buy the house together before you got married? Take a look at the tenancy. Is it tenants in common? Is it joint tenants? What is it? If you bought the house before you got married, it's probably joint tenants, and it probably references the wife's maiden name. So you should update your deed. You should change the tenancy to tenants by the entirety for the asset protection, and you should update the name while you're at it. Did you buy a house with an old girlfriend and then break up and never do anything about it? You need to update these things. You need to have an idea of how you are holding title to your properties. Go back, take a look at your deed. If you can't find it, if you don't understand what it says, if you're not sure what it means, give us a call, shoot us an email, send us a comment. We're happy to step in and we're happy to help you out.
That's going to wrap it up for today. So thank you for joining us for today for Real Estate with the Resnicks. Our next episode is going to be joined by a friend of ours, Brian Kessler, who's a loan officer with Direct Mortgage Loan, and we're very excited to have him catch up with us.
Yeah, thanks for joining us. Please give us a like or subscribe. Check us out at www.communitytn.com and send us comments about future topics and questions you would like to see. We'll see you next time in the conference room.